Assalamualaikum and hi. Today my group and I will be presenting our topic assignment on position of unregistered trademark in Malaysia. My name is Nurul Fanapiti Zairi and my matric number is 055093. Before we start, I would like to pass to my other members to introduce themselves.
Assalamualaikum and hi, I am Nur Atika Farhana binti Asmal. My matric number is 055387.
Assalamualaikum warahmatullahi wabarakatuh. My name is Rosnanita binti Rosid and my matric number is 054470.
For the introduction, we will look into the definition of the trademark itself. What is trademark? Generally, a trademark is a kind of intellectual property that consists of a recognized symbol, design or expression that distinguishes one source products or services from those of another. Section 3, Clause 1 of the Trademark Act 2019 states that trademark means any sign capable of being represented graphically which is capable of distinguishing goods or services of one undertaking from those of other undertakings. For an example, in Malaysia, we have so many people are setting up their business now due to the current pandemic outbreak as people are losing job. So some of them are selling the same thing and product. So how can you distinguish one brand to another brand that sell the same product? Through its trademark. For instance, McDonald's, we know its trademark by its symbol as well as its I'm loving it slogan. Next, moving on to the next slide, who can apply for trademark? By virtue of Section 17 of the Trademark Act, any individual or organisation who claim to be the genuine owner of the particular trademark can apply for trademark of their business. So how long does trademarks last in Malaysia? The validity term of a trademark registration in Malaysia is 10 years from the date of filing. Every 10 years, the Malaysian trademark must be renewed. If the renewal fee was not paid by the due date, a late renewal fee must be paid within 1 month of the last registration expiration date. Okay, now we move to the legal framework of Trademarks Act in Malaysia. Trademarks in Malaysia are governed by the new Trademarks Act 2019 and the Trademarks Regulations 2019, which came into force on 27 December 2019. And this repealed the Trademarks Act 1976 and the Trademarks Regulation 1997. The administration and practice of these laws come under the purview of the Intellectual Property Corporation of Malaysia. Malaysia is also a member of various trademark-related and WIPO-administered treaties, including the protocol relating to the Madrid Agreement concerning the international registration of marks, the Vienna Agreement establishing an international classification of the figurative elements of marks, as well as the Paris Convention for the Protection of Industrial Property. Thus, Malaysia has been a member of the World Trade Organization's agreements on trade-related aspects of intellectual property rights since 1st January 1995. So what happens if trademark is not being registered? First, business names, designs, works of creative will be at risk. It is easily will be infringed by the other people who try to produce the same product and service as the previous business owner. Second one is the burden of proving the validity and extent of its rights on the particular trademark lies on the brand's owner. And lastly, the genuine owner must strongly demonstrate goodwill and reputation associated with its unregistered trademark when it is used in combination with consumer products and services. So, does an unregistered trademark is protected under the Trademarks Act in Malaysia? Yes, unregistered trademark is protected in Malaysia but under the common law rights in the form of the thought of passing off. When compared to a registered trademark that enjoys some presumption of rights in the first instance, the burden of proof in a common law action for passing off is significantly higher. As a result, registration protection for trademark is usually recommended. Now, I will pass to the next presenter, Rosnanita, to continue on our next part.
Next, I will explain for registered trademark. Under Section 17 of the Trademark Act, anybody who claims to be the actual owner of a trademark may apply for its registration if the trademark is being used or will be used in the course of business. These non-traditional markings are approved in a various of established IP industries as long as they can be represented graphically. A collective mark is a sign that distinguishes the goods or services of the members of the association that owns the mark from those of other businesses. Due to some cooling of the previous trademark at 1976, archaic trademark ideas such as defensive marks and association of marks have been removed from the new statute. If you register your trademark under the Trademark Act 1976, you will have the exclusive right to restrict others from marketing identical or similar product under the same or confusingly similar names wherever in the country. Okay, for unregistered trademark, the Trademarks Act 2019 provides some relief to the users who otherwise would be unable to sue for trademark infringement. The same section specifies that no one will be able to sue to prevent or recover damages for unregistered trademark infringement. Malaysia adopts the first-to-use approach pending or unregistered marks have common law right in the form of the thought of passing off, providing they have established goodwill and reputation in the nation. In the case of Yongzi Fund and another, Perindustrian Makanan dan Minuman Layang-Layang versus Syarikat Zamani Haji Tamin Sendian Berhad and another, the court held that the defendant's appeal and counterclaim should be dismissed with the cause. The defendant misrepresented themselves, causing the plaintiff's goodwill to be harmed. The plaintiff had consistently and constantly utilized the Tamin trademark, and it had become a badge as well as an indication of their business goodwill. The procedure and remedies for an off-passing claim are the same for registered and unregistered marks. The burden of evidence is higher for unregistered marks because implementing goodwill and reputation is more complex. The procedure of registration trademark. Firstly, it is advisable to do a pre-filing search and research to determine the likelihood of trademark registration before filing the application. This search will be bound to the previous mark in the trademark registry database. Secondly is application. Allowing numerous classes in a single application also made trademark administration more efficient. This efficiency and production allow trademark owners to be better manage their portfolios by dividing and merging applications. After that, the formality examination. There will be an opportunity to respond or amend any irregularities discovered on the trademark applications. Next is publication in Malaysian IP Official Journal. This process involves filing the notice of opposition, counter statement, exchange of statutory declarations and legal submissions between the parties. Okay, lastly, the registrar will provide a notification of trademark registration after the trademark has been registered. If the registered proprietor requests a registration certificate, the registrar will issue the certificate of registration, which will be comparable to the trademark notification. Okay, that's all from me. I will pass to the next presenter.
The practice in Malaysia concerning unregistered trademark has incorporated the first-to-use concept, which provides that the trademark rights belong to the first company that used the mark in relation to the sale of goods or services on the market. The unregistered trademark owner may use the symbol TM to indicate that the mark is being used as a trademark, though it is not registered. This symbol serves the public as a notice and warns potential infringers that litigation action will be taken against them if they use the same marks. However, the courts in Malaysia have adopted the common law of passing off to protect unregistered trademark. The rationale behind this is that no one has the right to portray his good as possessions of another. As stated further in Section 159, nothing in the Act shall be construed to prejudice any person's ability to sue for passing off goods or services as those of another person or the remedies available concerning the goods or services. There are three essential elements must be met to establish a claim for passing off. First of all is goodwill, which requires the claimant to demonstrate that the mark is identifiable as being owned by the claimant and is acknowledged by the public or members of the trade. Reputation and goodwill are often seen as providing an identity to the company and its goods or services and distinguishing them from those of the same product. Secondly, the plaintiff must show that the element of misrepresentation was present. The defendant's actions have caused confusion among regular consumers and the public, whether deliberately or not. In their minds, the defendant's product and services are somehow linked to the plaintiff. As for the last requirement, the plaintiff must demonstrate that the misrepresentation has caused damage to his business in terms of financial and reputation. When people mistakenly believe that they are purchasing the plaintiff product when they are in fact purchasing the defendant product, the loss of revenue can be considered as primary damage. Issue: dangers of using unregistered trademark. The owner who own and use unregistered trademark has limited protection as the extent of this protection is somewhat unknown and relies on various factors. It will be difficult to establish all necessary elements of law of passing off. Unregistered trademark that have been produced, advertised, and already known in the business sector might be utilized by the unethical competitors. Goodwill associated with a brand name developed over time for a product may be put in jeopardy. One of the ways to minimize the issue is compulsory registration. Those who have registered with Suruhanjaya Syarikat Malaysia must register the trademarks that they have produced, owned and used for the business. Besides that, another way is limitation period, which the unregistered trademark shall only be valid for 3 years. After that, the owner of such trademark needs to officially register their trademarks. Next, to encourage people to register trademark, the Intellectual Property Corporation of Malaysia, MyIPO, may take action by making a pop-up booth in the appropriate site and links to the official site of MyIPO. Last but not least, the price of procedure and registration fees might be a challenge for small and online business owners. By reducing the fees, it may increase the people's interest in registering their trademarks.
In conclusion, trademark is important to the society as the trademarks help the consumers to differentiate the brand from one another. Moreover, trademark is essential for the business owner to boost their branding and marketing of their product. Thus, trademark also represents the reputation of the product to the consumers. After all, we can conclude that it is advisable for the people who just started the business to register their business trademark to avoid conflicts with copycats, counterfeiters that try to hijack their business reputation. With that, that is all from our presentation. Thank you so much for your kind attention.